Welcome to our CodeX group meeting. I am Roland, and it's my pleasure to introduce our speakers to you. We have two presentations lined up today for you all. We have Ryan Long, who's a principal attorney at Long and Associates and a non-residential fellow at our Center for Internet and Society. Ryan will be speaking about how we might be able to use AI to eliminate fake news and deep fakes, a very timely issue. And then we have Malcolm Gershel, who's the founder of the Gershel Law Corporation, who will talk about EMD, which is a matter management and process automation platform. So it should be an interesting conversation. Before we kick it off, I want to see if anyone wanted to share any updates with the group. And yeah, feel free to use the chat function or just unmute yourself so we can hear you.
So Rowan, it's Bruce. Hi.
Hey, Bruce.
So I sent a link to you and Mike earlier today. It seems like the California courts are requiring more and more e-brief and e-filing, and they're in that regard. They're requiring hyperlinks be embedded in the PDF, and so it seems like an opportunity for CodeX and CodeX members to think about the permanent archiving of whatever the hyperlink is linking to, so that a case brought in 2030 could refer to the PDF version of the similar fact pattern in 2020 and be able to find the hyperlink. And I don't know that we've actually thought about electronic document retention from a justice, an essential justice point of view, in terms of the wording of pleadings and filings that are made. But now that there's a trend to require electronic filings, how do we make sure that you can refer back to them 5-10 years hence? Yeah. Interesting
question. So yeah, we should start thinking about that. Maybe Bruce, you can maybe we'll do a little brainstorming session with this group and see what people think.
Yeah, I mean, it seems like a good white paper for us to at least raise some issues for it.
Yep, I think that's an interesting topic.
Okay.
Very interesting. Yeah, thanks for highlighting that. Anyone else wants to share anything with the group? Well, all right, and then let me turn it over to Ryan and his thoughts on AI and fake news. Ryan, are you there?
I think so. Am I here? Can you hear me okay?
Yay. Hey, Ryan, we can hear you well. Yes. How are you doing?
Good. How are you, Roland? Thanks for inviting me.
Good to have you. All right, take it away.
Okay. So what I plan on doing is presenting here. I have 15 minutes, Roland, right?
We only have two presentations today. So we started, it's about 1:34 now. So if you can go until like 2 o'clock. And
sorry, good.
And for your presentation, it'd be great if you had your presentation in like 10 minutes or 10-15 minutes, and then keep the rest for discussion with the group.
Yep, that's what I'll do. I'll finish it in 15. So yeah, if you have questions, just chat them away, and then we can talk about them at the end, if that's okay. Usually if this is a live audience, I'd kind of interact more, but given we're virtual, it's kind of the way it is. So I have here in my document, section 230 in AI. Friends, foes, or somewhere in between. So fake news, deep fakes, what are they and why should you care? And what if robots or bots programmed with AI could get rid of fake news or deep fakes, all or some of them? And even if AI could do this, what if Section 230 of the Communications and Decency Act of 1996 would protect this content online? So that's the subject of my talk today. And to preview it, I'm going to give you a little bit of a hypo to start out. And then I'm going to look at the law before 230. Again, when I say 230, it's the Communications Decency Act of 1996. So we're going to look at the law a little bit before 230. And then I'm going to look at what the landscape looked like post 230. And then I'm going to look at, we're going to discuss or present on artificial intelligence and how does that seek to solve the problem of fake news and deep fakes. And then just a closing remark. So on that note, the Facebook hypo. So the Facebook hypo I thought of here is that Dan Rather goes on Facebook and he writes, and Dan Rather's a reporter, just in case you don't know who he is. And he goes on his Facebook and he says, Starbucks is a fraud. Coffee is U-Ban decaf. U-Ban's an old brand. Coffee is U-Ban decaf. Plus, they punish employees by pouring hot U-Ban over their heads. Abusive labor practice, exclamation. Hashtag boycott Starbucks. So that's what he posts, Mr. Rather. He goes on Facebook and does this. That's Facebook post number 1. So assume that Mr. Rather's statement's untrue, it would arguably be defamation per se, and obviously it's untrue. So if it's defamation per se, it's an untrue statement that injures Starbucks' reputation, it implicates fraud, and that's within the categories of what they call defamation per se. It's also fake news, and I have a definition here of fake news that isn't the only one, but it's one of them. A 60 Minutes producer defines fake news to be stories that are provably false, have enormous traction, a popular appeal, and are consumed by millions of people. So I'll say it one more time just in case you didn't hear it. Stories that are provably false, have enormous traction, they're popular appeal, and are consumed by millions of people. So what isn't included in fake news is satire. Satire is fake news, but it's funny. So Saturday Night Live skit, if you look at the Weekend Update on Saturday nights, they have a lot of fake news on there, and it's satire. So that's not included in the definition. That's clearly lawful stuff, even if it's would be defamatory if it weren't satire. So you have Facebook post number 1 by Mr. Rather. Facebook post number 2. Mr. Rather posted a video of Kevin Johnson, Mr. Kevin Johnson, CEO of Starbucks. And in the video, Mr. Johnson is pouring hot coffee over the head of an employee. The video is a doctored version of a Super Bowl video in which Gatorade is poured over the San Francisco 49ers head coach. So there's 2 postings. One is a fake news, and the second is what we call a deep fake. So what is a deep fake? Basically, it's a doctor video. The doctor video is a deep fake. And deep fakes come in many forms: photos, videos, and recordings. And they're basically modifications of the original. There's a software in Canada, for instance, where you can record somebody's voice and then basically you can sync that voice over a video of them and have them say whatever you want. So that's a deep fake. And sometimes they're very hard to tell from the original. So what's another aspect of this phenomenon? We have accepted as true. The 2 posts are accepted as true. Both posts scale. They get millions of hits. Now we have Miss Tina Turner, the famous recording artist. She reposts both on Twitter. So Facebook knows about the posts, but let's say, and refuses to take them down, even after a cease and desist letter from Starbucks. It's your Starbucks counsel, you send them a cease and desist letter. Starbucks says, no, we're not taking them, Facebook says we're not taking them down. Meanwhile, Starbucks stock takes a tailspin. People start thinking what is said about Starbucks is true. So people stop buying Starbucks, and all of a sudden you have a fiasco in the marketplace in terms of Starbucks stock. If you think this is fiction, it's not. The European Research Council a study said 1 in 4 Americans visited at least one fake news article during the 2016 campaign. So that's quite a lot. So I have some questions here. Can Starbucks use federal law to get the post removed from Facebook? What about other social media websites? Can Starbucks go to Twitter and say, you need to take that down? What about Ms. Turner? Can Starbucks sue Mrs. Turner? Can they sue Facebook or Twitter for defamation? No, the conversation here has nothing to do with Facebook's terms and conditions, nor Twitter's, because these posts might otherwise violate the terms and conditions of Facebook and Twitter, and that's not the subject of my conversation. So what about artificial intelligence? What about bots programmed with AI? A bot is basically a virtual robot online. What if AI could flag Mr. Rather's fake news either after it's posted, so it's taken down, or before? Right, when he's posting it, it could stop it from being posted, for instance. What about the deepfake video? What if AI could basically stop that from being posted, or right after it's posted, not wait for people to flag it? Does it matter if AI can do this? And that's the subject of this talk. So now we look at the issue, and now we're going to look at pre-Section 230. So what did the world look like before this law was passed, Section 230? So there's two seminal cases I'm going to go over here. One is a Cubby case, and it basically said there's no social media liability. And in Cubby, there were defamation claims brought against CompuServe, and the court basically said CompuServe wasn't liable for the defamatory content on it because it had no reason to know the content, and it acted as a passive conduit. So that's Cubby Inc. versus CompuServe. It's a case out of the Southern District of New York in 1991. So that's a passive conduit case, and there's no liability there. In another case, it's called Stratton Oakmont versus Prodigy Services. There was a summary judgment in favor of the plaintiff because for defamation claims brought against Prodigy, because the defendant did exercise editorial control, and so it was more akin to a newspaper. So when you have a newspaper and you're editing the newspaper, you're actually controlling the content. So that's the dichotomy that existed before 230. No liability if you're a passive conduit, you'd have no reason to know of the defamatory content. Liability if you know about the content and you do nothing about it, and you have a control over the content on your site. So what is Section 230? There's more to it than what I'm going to show you, but Exhibit A, let's see here. Can you all see Exhibit A? Roland, is that
no.
out? What's that?
No, I don't know. How can we show it? Susan, I think, has
yeah, we tested it, Ryan. You were able to show it when you had your screen share in your desktop. So are you sharing your desktop?
Okay.
So open your file on your desktop and then share your desktop.
Okay. Can you see it now?
Not yet.
No. There you go. Now we see it.
Okay. So this is Exhibit A. And you'll see treatment of publisher or speaker. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. I'm not going to read the whole thing here, but this is basically what one of the seminal parts of Section 230. And a big part of the dispute right now is that there's a section here, 2A, which says any action voluntary taken in good faith to restrict access to or availability of material. So big issue that President Trump had in his recent proposal was questioning whether or not somebody's protected by this if it was in bad faith. So there's a lawsuit pending about that. So this is Section A. Section B, excuse me, not Section B, but Exhibit B is 230F2. I'll pull that up. And this defines an interactive computer service. Can you all see that?
Yes.
Okay. So basically, this includes Facebook, Twitter. It's been extended to Craigslist, and we'll get to that in a short while here. So what's the scope of 230? Can you all hear me okay? I don't know if I did anything here to modify. Can you hear me okay?
We can hear you well.
Okay, great. So what's the scope of 230? What causes of action are exempted? Well, defamation is exempted. So untrue statements hurting your reputation, those are exempted if posted on an interactive computer service. Negligence is exempted. So accidentally permitting defamation, fake news, or deep fakes if you have an interactive computer service. Cyber stalking, so if you're stalking somebody using an internet computer service, that's exempted. What isn't exempted under 230? Copyright. So Mr. Rather's video used Starbucks song. If it synced a song from Starbucks along with the images, that's not exempt. Starbucks could actually take that down. Trademark. Let's say the video used a Starbucks trademark. In that case, Starbucks could reach out and say, hey, you need to take that down. You're infringing our trademark, or you're diluting it. So what is an interactive computer service? How broadly has that been defined by the courts? It has included online matchmaking, fake news and deepfakes are okay in online matchmaking. Employer-provided interactive systems. So if you provide an email system to somebody and they're using it for a certain, they're defaming somebody, you can be exempted. So it's pretty broad. 230 has also been applied to third parties who republish. So in Miss Turner's case, when she republishes, she would be protected. We'll get to that in a second. Now, editorial function. So if you run a website, and let's say you're Mr. Zuckerberg and you run Facebook, what will allow you to be protected and what will allow you not, or what will take you out of the protection of 230. So traditional editorial functions are permissible. So if you delete or publish a post, that's permissible and you're within 230. If you start modifying the basic form of the message, then you're taking yourself outside of the protection of 230. So for instance, if Twitter changed coffee to deadly acid in Mr. Rather's post, they would probably be liable for the post because now they're taking an editorial action regarding the content. Okay, so what does it look like with common law? Compare 230 with common law. Under common law, can Mr. Rather be liable to Starbucks for his post? What about Facebook, Twitter, or Ms. Turner? Potentially. What about under 230? Mr. Rather could potentially be liable for the post, notwithstanding 230. Facebook, Twitter, and Ms. Turner, no, under 230. So this juxtaposition as to why some have suggested to revoke 230 or modify it, including former Vice President Biden and President Trump. But there's issues of scale. Facebook has 2.7 billion users. Twitter accounts 1.3 billion. So there's a lot of folks on these sites, and policing can be very impracticable, which is one of the reasons why they passed 230. So how can AI help with fake news and deepfakes? So I'd like to direct your attention to Exhibit C. And let me get it up for you. Can you see Exhibit C? Yes?
Yeah.
Okay. So here I have an example of a post. It's a newspaper article, and you see it's very primitive. It shows information on there that's deemed to be untrue. No, they don't. Threatens to ban. No, they won't. No, they don't. No, it hasn't. So basically the way the AI works, and I'm going to get to the second here, is basically it crawls the internet for certain terms and then basically flags them. So one of the ways that this has been done recently, the technology, OpenAI's GP2 language model. It's an auto-completion detection AI basically. So the way that works is they would search the internet for banned, threatens to ban within, let's say, 10 of German children together, German children quotes. It's an oversimplification, but basically that's the way it works. And imagine it being like a spider that crawls the internet, and you do basically searches, but you program AI to do the searches for you. So another program that's out there is Israel's Check. It basically assists media companies and gives them parameters for which websites they should basically post their ads. And they look at website reputation. Has there been fake news before? Is it a bot or not? Grover is by the Allen Institute for AI and the Paul G. Allen School of Computer Science. It basically generates fake news, but also can detect whether or not something is generated by AI. So it's a generator and also a monitor of fake news, AI generated content. So what are the limitations of AI? Well, I have garbage in, garbage out. So AI needs to know that Starbucks CEO is currently Kevin Johnson and not Magic Johnson. If you program it incorrectly, it won't be able to flag it. It would also need to know the original video of the 49ers and not of Starbucks CEO in the video that is programmed with. Also, you need to update AI basically 24 hours a day, because what's true of yesterday, the world people thought the world was flat, is not true today. Also, there's common sense lacking. Professor of computer science, Yoav Shoham, basically says that AI still can't exhibit the common sense or the great intelligence of even a 5-year-old. And one example is sarcasm. I have here a joke. I hate it when I go to hug someone really sexy and my face smashes right into the mirror. So AI can't pick up that that's a joke. It might flag that as a true statement or untrue statement, but it can't pick up on satire or nuances. So then my next exhibit is the Turing test, and this plays into syntax. So if you look at the computer responding on the left, that's going to be programmed, right? You're going to program information into it. The human questioner is in the middle, and the human respondent is on the right. So if you program into, this is a very simplistic explanation, and we're running out of time here, but in the Turing example, if I program into the computer, the answer to the question is my face smashes into the mirror, when the question is, when I go to hug someone really sexy, what happens? Then it would give you that answer. Now, if I teach the human respondent the same question answer, she or he will say the same thing, but neither will realize that it's satire or humor. And that's basically Turing's, the professor from Berkeley, Searle, his Chinese room test, and that's exhibit E. So as you'll see, you can give him information regarding inputs and outputs. If you see this shape on the right, then produce this shape in Chinese. So he can be sitting in this room all by himself, and you can give him these symbols, and he can output these symbols. And you say, well, Professor Searle speaks Chinese, but he doesn't. I mean, he can speak it ostensibly, but he doesn't understand what he's saying. So he's akin to a parrot. So that's their critique of AI, that you basically have inputs and outputs, and it doesn't know what it's doing really. So the closing remark I have is that basically that AI potentially should track 230. So if people are programming AI to track or to flag fake news or deepfake content, that they should do carve-outs for certain sites, because basically it's the site's responsibility, or I should say prerogative, to leave it up or take it down. So on that note, I'm finished with my presentation, and thank you.
Great, thanks, Ryan. Very interesting. So is that something that that some of those platforms are already considering or already working on?
No, that's a good question. I don't know. I haven't looked into whether or not like Facebook or other sites are saying, because I think what they do on like Facebook or Twitter is that they have AI themselves, but their interest is different. They're looking for basically whether or not things that are put on their websites comply with their terms and conditions. So if they find something that violates, like in Facebook, there are certain terms and conditions, and there's certain things that may be violated. So they do have AI rolling that will flag stuff as potentially being fake news
right,
or a deep fake. So it's an answer to your question, yes.
Okay. So Rachel is raising her hand. Rachel, are you there?
Yes, this is actually touching on a lot of the research I'm looking at. One of the issues that occurs to me here is there's surely a First Amendment issue with letting AI do this work, because there's no guarantee that whatever it flags is actually going to be fake. And even if it is fake, surely it's still the right of the person posting it to post it under the First Amendment.
That's a great question. I agree with you. I think, as I said earlier, it's what you program AI to do, right? So, if you program AI to say that the joke, I hate it when I go to hug someone really sexy and my face smashes right into the mirror, is false, because you don't smash into the mirror when you go to hug someone really sexy, then that's absurd. So you're right. This could be used to basically squelch speech that is basically protected by the First Amendment, depending on what, it really depends on how you program the AI. For instance, if AI is programmed to say that Magic Johnson's the CEO of Starbucks, it's going to flag true statements about Mr. Johnson, right, and say that they're false, even though they're true. So Rachel, yeah, I agree with you. I think this could potentially chill protected First Amendment speech, depending on how you program the software.
Yeah, and I think you'd probably need a Supreme Court decision to actually decide how far it would be pushed, because you could end up with some very interesting cases coming at the lower courts.
I agree. I mean, basically, if the state basically uses AI, I mean, there's case law on this. Like, if the state uses a third party to squelch your First Amendment rights and they're working in concert, there's well-established case law that says both the private entity and the state can be liable, Rachel. So if there's a software company that's being used by the state and the state's using that software company to go after people for protected speech, both could be potentially liable under the First Amendment. In America, at least. I don't know in England or in the UK.
Right. What's sort of your kind of objective for the project? What is sort of the next steps in this research?
Oh, in my research, I mean,
yeah.
I'd like to just, at some point, I like to see about. That's a good question. I haven't really thought about that. I mean, I think, like, when you're doing AI or if you're a computer scientist, like, do you want to program AI so that it flags things that are basically allowed under 230? I mean, that would be my thought for, how do you make your AI more kind of consistent with the law would be my next kind of step in this. Because if you're flagging things on Facebook or Twitter that Facebook or Twitter has the right to keep up, then why do you even go through the process of flagging it? It's their business whether or not they want to keep it up or not.
Right. Well, I think, so isn't it like in defamation law, there's this line drawn between stating something as the truth and stating something as an opinion, right? So as long as you're stating something as an opinion, then you're in the clear, right? And shouldn't there be some, fake news is a problem because information is passed off as being true and as a statement of fact, right? When in fact it's not true. And so, I think we can see the harmful effects of fake news. And so I feel like you're saying that, we shouldn't create AI that flags fake news because you feel like it should be covered by 230. I'm not quite sure.
I mean, if a newspaper publishes something about a public figure, like Mr. Johnson, and they knowingly publish it, knowing that it's false, they could be liable under current law, right? So that's New York Times versus Sullivan. If they maliciously post something about Starbucks, like in this example, Mr. Rather, who's a journalist. So let's back up. If Mr. Rather posted this and he knew it was false, which is obviously false, and he did it to injure Starbucks, he could be liable even under current law, right? So that's liable. That's fake news that you can get in trouble for. What I wasn't suggesting is that AI shouldn't flag fake news. What I was suggesting is that 230 gives basically the right to Facebook to keep this up or not. And so by programming software to impinge upon the rights of Facebook or Twitter, when they have the right to keep this up or not, is kind of like a waste of time, is my point. It's not really an efficient use of the software. And you're basically, I mean, I don't know, there's software that's licensed by different companies, and that's relevant for licensing issues, right? I mean, you can't tell somebody that your software is going to take things down that are fake news when Facebook can say, that's our right to keep it up or not. So, you can't come and tell me to take it down because under 230, I have the right to keep it up. So it's relevant, Roland, for basically software developers, for license agreements of what the software can do from a technological perspective, but also what you warrant and represent the software to do to licensees.
Got it. Okay. All right.
Yeah, Rowan, I had a quick question for Ryan. I like your example of the financial markets reacting to fake news, and I wonder how you could actually test different AI software's approaches to see how the market capitalization or other pricing data react in real time to fake news while it's up and once it's taken down. So isn't that a large data set that could be used alongside of the AI to prove the value of this?
I totally agree with you. Yes. I mean, there's an example I didn't provide to you all, but basically the SEC brought a securities fraud case against a guy who posted on Twitter about a public stock, and it dropped the stock price, and he got a complaint filed against him. I don't know if it was a criminal, it might have been a civil case. I have the post, but Bruce, this happened about a year or two ago, and the guy got charged by the SEC for securities fraud. So this is real. I mean, in this case, if Mr. Rather did this, and it affected the price of Starbucks, he can get in trouble with the SEC. So one of the exemptions I didn't go through that 230 doesn't apply to is securities fraud in certain federal criminal statutes. So if he was committing securities fraud on Facebook, Facebook knew about it, Facebook could potentially be liable. But in answer to your question, the answer is yes. I think that's a great point. And to what extent do fake posts by people that are intentionally trying to injure somebody's stock, to what extent they can drop the stock is very relevant, and how do you stop that from happening? But those statements, or Mr. Rather's statement, could be actionable.
Yeah, I just think it would be more convincing, let us say, to Facebook and Twitter and the other social media if they start getting lawsuits on the securities side. And I think that would be an interesting evolution in social media, is to start getting sued for the fake news effect on their either stock price or their ability to get financing.
That's a good point. Yeah, I mean, you're blurring into securities fraud and securities regulation, and I didn't go into this in the presentation, but there are proposals by states' attorneys general to not include state criminal laws in the exemption. The exemption under 230 is very big. I mean, you'd be surprised how big it is. It applies to fair housing law, where people are posting no minorities on Craigslist. They're protected. There was somebody posting very aggressive, awful things about Muslims on a website, and the website was exempted, even though it violated basically equal protection or certain civil rights laws. So, but there are carve-outs for federal criminal law. So I agree with you. I think that if there's some cases where they come along where people are basically using Facebook or Twitter to basically commit securities fraud, and they're like short selling, for instance, a stock, and they're intentionally demolishing it so they can short sell, or whatever, long or short, whatever, then yeah, there could be potential liability, I would imagine. I mean, I haven't looked into the cases and stuff, Bruce, but yeah, that's a new area.
Sounds like some good plaintiffs' counsel's work. Go for it.
Well, on that note, okay.
Can I just ask one further question, if possible?
Okay, one more question, and we'll have to turn it over to our next speaker.
Sorry, yeah, it's just a very quick one. Just about the DMCA, you touched on copyright previously, and one of the issues that YouTube's having with its user base is they're taking down a lot of videos on automated flagging. So could there be lessons learned for this based on what's already happening with the DMCA issues?
I agree, yes.
Cool.
I think that the DMCA is a good model for 230. I mean, right now, there's no takedown procedure for 230. Vice President Biden has proposed actually revoking 230. President Trump has something that basically limited 230, and it's being litigated in court right now, Rachel. So, and the legislature hasn't spoken yet, but one potential way to handle this is what you just said, which is to model it after the DMCA, like the takedown procedure.
Cool.
But that answers your question, I think.
Thank you so much, Ryan. Thank you for joining us and for your presentation. I think it's a really interesting topic.
Thanks for listening.
And very much appreciate you filling us in on your work. And yeah, thanks again for joining us.
Hey, Ryan. Yeah. Oh, sorry, Roland. Maybe you were going to ask Ryan to drop his email into chat.
Oh, yeah. So exactly. So yeah, if you could put your email address into the chat so that folks who might have additional questions for you could follow up directly with you, that would be great.
Yeah, I'll do that right now.
Okay.
It says chat disabled on my thing here.
Really? That's weird.
Yeah. Can I give you my email and then somebody, for some reason I can't, it says chat disabled.
Oh,
So Ryan, do you want your Gmail address? I'll drop your Gmail address into chat.
That's fine.
Okay,
No problem.
great. I'll do that.
okay. Thanks, Susan. Thank you, Ryan. Good to have you, Ryan. And all right, so let me turn it over to Malcolm now. Malcolm, you there?
Yes, I'm here. How are you? Ryan, that was really fascinating, really interesting topic. I hope that mine is somewhat interesting as well. Just going to make sure I got my video there and share my screen. A little presentation. Let's see. Okay. Can everyone see my screen?
Yes, perfect.
Okay, great. Thanks again for having me. And what I wanted to talk about is how myself and my firm is using automation and technology to really improve our processes in terms of doing a high volume practice of law. We do business immigration. And also to help our clients automate compliance management. And this, is particularly relevant, I think, these days for immigration lawyers, given a couple of things, the Trump administration. And I think there's no secret that Trump is no friend of immigration. And he's, really sort of, the administration is amping up on enforcement and investigations, or at least that's what they say they're going to do. And they've been doing to a certain extent. And also, of course, the current COVID-19 pandemic, and I'll explain how that's relevant to what we do as we go through the presentation. The presentation is sort of in the form of a pitch deck, but really, I just wanted to, share how we're using technology in our type of practice. So, hopefully we'll have plenty of time to answer questions. So I'm going to give an introduction and some background about myself and my practice, and then I'll talk about the products that we've developed that we use in-house, and we're also licensing to a couple other firms, and hopefully we'll be licensing to other firms to help them to automate their processes as well. Talk a little bit more about the current legal landscape with what's going on with a lot of executive orders from the administration and travel bans and other things that impact our business, and then how we're using technology specifically to deal with these unprecedented and rapidly evolving changes in policies and laws. So a little bit about me. That's me pre-COVID-19. I've been practicing business immigration for over 20 years, and we represent a lot of companies. I've represented some very large multinationals and also represent startups. Used to be a partner in a very large multinational firm. And I've been working on developing software. I'm not a programmer, I'm not a software developer, but I've been working on developing software to automate the process of business immigration for really almost my whole career. I kind of realized early on that a lot of what we do doesn't require a human being or a lawyer or paralegal to do. And I've tried to figure out ways to minimize the human element of a lot of what we do, which is just to improve efficiency and also to give our clients an overall better experience, faster turnaround, et cetera, et cetera. So we've done some research on this, and we've determined that 22% of lawyers' jobs and maybe 35% of paralegals' jobs can be automated. I think that in our practice of business immigration, it's probably actually even more than that. A lot of what we do requires a lot of legal work and a lot of strategic thinking, but a lot of it's also fairly repetitive and doing the same cases hundreds of the same cases, sometimes hundreds of the same cases in a month. So it can be automated. And what this has really sort of allowed my firm to do is to frankly, increase the bottom line, to do more work with less people, increase our profit margin, and at the same time offer a better client experience through unique tools and faster turnaround and automation. So now I'm going to talk a little bit about our products. Sort of the, I guess you could say, flagship product that we've developed, and this has been in development for a long time, is what we call Agnos. Used to call it MED, and we changed the name to Agnos because people think it sounds better. Essentially what this is a very flexible matter management system. I know there's a lot of things out there that do similar stuff, but the theory that we started with this, and the reason that we call it Agnos, which is sort of short for agnostic, is that you can use the system and it can be adapted for just a wide variety of different kinds of high volume legal practices. So it's not specific to immigration. Obviously, we use it for immigration, and also to automate different processes and workflows, and do that in a way that's developerless. And what I mean by that is that it's not something that has to be configured or designed by developers. It's set up with sort of a least common denominator type of theory where you can configure it to your processes and customize the templates, the emails, and automate emails and reminders and billing, et cetera, et cetera. So that's kind of the main product that we've developed and we use in-house, and we've licensed to a couple of the firms. The other thing that's really very specific to immigration that has to do with compliance automation is intra-LCA. We developed this tool specifically because a huge part of the immigration practice, the labor condition application, is what we do every day. So anytime that an H-1B is filed, which is, I'm sure a lot of you have heard of, we file a labor condition application. And it requires a very sort of, complex, or not complex, but convoluted process to meet certain milestones. The posting the notice has to be done before we file it. And of course, with business immigration, things are rapidly changing, and people want things done on very short notice. So we've developed this product that, first of all, sort of integrates to the DOL system, even though the DOL doesn't have an API. So it's using, I guess you can call them bots, to fill out the forms in the DOL system. And without that sort of technology, other firms may spend 10 or 15 minutes to fill out the form, which doesn't sound like a lot of time. But when you're talking about doing 100 of them a day, it is a lot of time for a paralegal or an attorney. And our system has, really reduced it to 30 seconds. So that's one of the, I would say, one of the key things that we've done, and what some other firms are most interested in doing is to automate that part of the process. But it also goes further than that. It automates posting notices posting notices at clients' sites automatically. And that, I think, is particularly, we'll talk about a little bit more when we talk specifically about COVID and the current environment in immigration. But it allows us to not only automate our own processes, but help our clients automate their internal processes in terms of posting notices on their intranet site. The other product we call workvisa.io, and this is also something that we've had a lot of interest in from our clients and some other firms. And this is a tool that's used to assess immigration risk for recruiting. We have a partnership and integration with Greenhouse, which is a very well-known and widely used applicant tracking system. Most of our clients use it. so that it's integrated in a way that recruiters can initiate an assessment process as they're going through, you know, the recruitment process, and it will send a questionnaire automatically to the applicant, and then it comes to the attorney, and the attorney can review the documents and get back to the recruiter quickly with an assessment of any kind of risk, immigration risk that there may be with a particular candidate. Our clients also use it for some other sort of related things, assessing risk in terms of export controls, something that comes up, and they, you know, we put that into some of our questionnaires. So that's something that we'll also talk a little bit more about. It's very flexible. It can be used for any kind of regime. So some of our clients are using it for Canada and other countries where they have hiring, where they're increasing hiring. So want to talk a little bit about the current legal landscape, and then we'll talk about how our technology is addressing some of these challenges. I'm sure everybody's heard about the international travel bans because of COVID. Europe, Brazil, China, UK, and Ireland, for people that are not permanent residents or US citizens, are banned if they've been to those countries for 14 days. Suspension of routine visa services. Most of the US consulates around the world are not issuing routine visas, only emergency and in some cases F visas. And work from home policies. So a lot of our clients and a lot of companies these days have policies where people need to work from home. Maintenance of status issues. This comes up a lot in the context of terminations or furloughs where the person's no longer working for their employer and they have to go off payroll. And then, you know, the trends that we're seeing with global relocation and hiring, there's just a lot more companies that are hiring their talent outside the US. And as part of the international travel bans, you know, I'm sure everybody's heard of the Trump administration, the executive orders or the proclamations that are essentially suspending certain work visas and immigrant visas, green card visas. I think the way that I would describe it is there's just sort of a convergence of, you know, factors that have led to compliance hell. And we'll talk about how that relates to what we do. So what the platform allows us to do is to enable rules to flag when an employee is currently abroad. So we integrate with other systems, the DHS. Again, they're not really integration because they don't have APIs, and it sometimes is very challenging because we have to be very careful in how we do it so that we're not violating any terms and conditions. But we can actually go into the DHS system and pull information and know when one of our clients has left the country or has re-entered the country. And that can be very important because if they leave the country, they can be stuck outside for a very long time. If they re-enter the country, there may have been a mistake at the CBP, which will make it, you know, very difficult and compromise their maintenance of status, which is much more critical these days because of all of the issues. You know, if they're forced to leave the country, they may not be able to come back for a very long time. So we can configure it to do those type of things, integrating with government systems, and flag all sorts of alerts when people change locations. With most of the immigration categories that we deal with every day, we need to know where the person's working, even if it's in the United States. If they change locations, we need to be able to know that and file an amendment. Otherwise, the company is going to be subject to investigation and possible penalties, and the individual from removal from the United States. Because people are working from home and they're deciding that, you know, I don't want to work in the Bay Area. If I'm going to work from home, I'm going to go work from, you know, Kentucky or something where things are a lot cheaper. Knowing this and being able to track this and track specifically how many days that they are working outside of the area where we filed the petition becomes very important. So the intra-LCA capabilities that we discussed and how that relates to the current environment, this has really sort of helped us out a lot, because we've, with a lot of these categories, there has to be a notice posted before we can file the LCA, as I mentioned before. And the way that a lot of companies do that is with a physical bulletin board posting. And that's very difficult when nobody's in the office and people are working from home. Obviously, sending a physical posting notice to everybody's home office is not really feasible. Our system can be used to actually post the notice electronically through their internal intranet system instantaneously, so everybody that is working from home will get notice right away. And we've had this functionality for quite a long time. And just when this whole COVID thing happened and the work from home, I would say maybe, 20, 25% of our clients were using it. Now every one of them pretty much is using it because they need to. And then, the work visa capability, as I mentioned, a lot of companies are now moving people to other countries. And there's also people that are traveling to countries as business visitors where the restrictions are changing frequently. So this capability allows not only to assess whether someone is going to need to, there's going to be immigration risks and what kind of time frame and cost is involved in the recruitment stage for new employees, but it also helps to assess any kind of risk for existing employees that are traveling to other countries for business trips through a portal where they can pick the country that they're going to and the purpose of their travel, and we can provide some guidance on that. So that's basic, just a quick summary of how our system is being used to face the current we say confluence of unfortunate events that we're faced with today. And just wanted to talk briefly about where we're going with this. As I mentioned, we use it internally.
Malcolm,
yeah,
just be sure to leave a little bit of time for discussion.
Okay, sorry. Yeah, I'll just leave it right there then.
Sorry, I didn't want to interrupt your flow. So if you want to
totally
wrap up, please do that.
I have a tendency to talk too much, so I'll just leave it right. I think we've gone through the presentation and would love to hear some questions or comments.
Yeah. So my first question is thanks for your presentation, and I think it's very interesting. And what interests me in particular is maybe not so much the specific functionality in the immigration space, although I think that's it seems very, very useful and seems to be possible to save a lot of time. But I'm also interested in where the legal profession is going and how it is or how it is not embracing technology. And so it seems to me that you and your firm are proactively embracing technology, creating technology, and then making that available to your clients, and then possibly also licensing it to other lawyers who can use it, even to compete with you potentially, or to use it in different practice areas. I just think it seems to be that a few number of firms are actually starting to build technology themselves, and some of them create their own subsidiaries, which are technology companies, and they then make that technology available either just to clients or to other lawyers too. I'm curious to hear a little bit, I would love for you to share a little bit of your thought process around it and how that conversation went. I don't know how big your firm is, if there are other decision makers or you're the only decision maker there. So if you could share a little bit of that process, I think that'd be very interesting.
Yeah, so I'm the only decision maker, for better or for worse. I think that the reason that I was compelled to do this is just that the products on the market were not really serving our needs. You know, the reason that we're seeing a lot of interest in it right now, you know, we haven't really sort of been able to sort of close any big deals. I think it's very hard. The legal practice is very conservative. But we have a lot of interest, and we're, you know, is that the products that are out there are very rigid. They don't allow the kind of flexibility to deal with the challenges like we just talked about that do come up. And when you do adjust them, it requires a lot of expense and time to have developers to do that. I think more importantly, it sort of makes law firms' data captive. And once they're in the system, it's very difficult to get it out. And that's kind of what we were trying to address. And I always had the idea of doing this for something beyond just immigration, to have that kind of flexibility so that other firms can use it. And I think that, you know, as I look back on the many years that I've done it, it's been a very large investment. And sometimes I think, why the hell did I do that? But I also look at it in terms of what it's gained the firm. And although it cost quite a bit of money, I think in the end, we've certainly broken even with maintaining client relationships and reducing our overhead. And we're probably more profitable than a similar sized firm of our, you know, 20 employees with 4 attorneys, because we've made this, you know, very significant investment for a firm our size into technology.
Got it. Thank you. Does anyone else have any questions for Malcolm? How do you, I mean, how do you make your technology available? Is it licensed? Is it sort of on-prem, or is it a subscription? Is it subscription?
It's a, you know, it's a cloud-based solution. So if someone, and this also is a little bit unique from similar type of products. If someone licenses it, they have their own instance on their own virtual server. So it's not sort of commingling data with other firms. So we set up a server on AWS that's specific to that law firm, and the license is by seat. So someone that has, you know, 20 employees that need to access it would pay 20 licenses, essentially.
Rachel is raising her hand. Can you speak up? Yeah.
Just a quick question, Ryan. Sorry, just in terms of the data entry side, how do you mitigate for any errors when you're doing the data entry? Do you have someone just proofreading it as the information is put in?
I'm not sure I understand.
I used to work as a legal secretary, essentially doing form filling. So when you've got the automated form filling.
Yeah, I mean, in terms of tracking errors, I mean, one thing that we do is when we collect information, we have an electronic system. So a lot of the communication is automated, and the individual fills out the data on electronic questionnaire, and we can create and modify those questionnaires however we need to. And when they're entering their own data, they're much less likely to make a mistake on their date of birth or their, you know, their first or last name. So I think that sort of, you know, alleviates part of the burden of making sure that there's not those kinds of mistakes. And it also just reduces data entry altogether. I mean, basically anything that we need, we can collect in an electronic questionnaire from the client. Okay,
so Agiri, I think, has a question too. Agiri, are you there?
Yes, hi. Thank you for this presentation. I have a question with regard to data privacy and how do you deal with consents of subjects, and whether you're looking into consent like in a continuous matter. So if an employee has agreed that that traveling is being tracked, up until when is this consent sort of valid for you, for your system?
I mean, I think those are good questions. I think as immigration lawyers, I mean, I think it's a very good question. We have to know what our clients are doing, and if the system's not doing it, and we haven't sort of, for other reasons, compliance reasons, and you know, we don't want to get in trouble with the DHS. We haven't actively implemented something where it's a bot is harvesting that information, but it's something that's turned off that could be turned on. But I think that we are checking that anyway, and we have to check that in order to serve our clients. We need to know if they've entered or left. So I guess the question is if you're sort of doing that automatically, and if you have a system that's doing it for you, do you need a separate consent aside from, you know, the legal representation side of it?
Yeah.
And I honestly, I don't have a good answer for that. I mean, is everything that you do if you're representing something, is everything that you do through technology, do you need a separate consent aside from, you know, an engagement letter and the attorney relationship that you establish with the client?
Yeah, makes sense. Yeah. So you're proceeding on the base of that.
Yeah.
Cool. Thank you.
All right, so we're already a little bit over our time. So let me thank you, Malcolm, for your presentation, for joining us and sharing your work with us. And thank you also, Ryan, and for sharing your work with us. I'm really thrilled that we could learn from you today. And hope you keep us posted on your progress with your projects. Malcolm, if you could maybe put your email address. Oh, here's a contact info is on this slide. Okay, so if anyone has any additional questions for Ryan, then perhaps that's a good way to reach you.
Malcolm, yeah.
Oh, sorry, from Malcolm. Sorry, from Malcolm. Malcolm, would that...
Don't reach Ryan, don't use that email address.
All right. So no, but on this slide, Malcolm, so if folks have follow-up questions, they should just write you at info@eMeeting.
Yeah, so that's the company, and you know, the people that are handling that can definitely answer any questions about the software. Yeah, I mean, we're happy to, would love to hear people's feedback.
Okay, good. Well, thank you both. Thank you so much for joining us. And Susan, if you do we have a presentation next week, or what's?
So next week we have a little break, and then we'll be back on October 8th. So we'll look forward to seeing everybody then. So watch for Roland's announcement that week.
Okay, we'll send something out, and you see you all October 8th. And yeah, all right. Thank you all, and see you soon. Thanks again. Bye-bye.